It's Thursday, so we always have a Justice Thursdays conversation. We, for a while now, have been talking about the alternative justice system. We know that the AJS courts were launched last year, and we spoke with the people who are launching these courts and understanding what alternative justice system is. The first one to be unveiled was in Kajiado, and then they went around the country. Nakuru was also unveiled. Now we want to find out how exactly do they work and how has this been working. So the National Steering Committee on the Implementation of the Alternative Justice System Policy is represented in the studio this morning by the Vice Chairperson, who's Dr. Steve Ouma Akoth, and a member of the committee, who is Maurice Kimoli. Good morning, gentlemen.
Good morning.
Good morning.
Karibuni sana to Kenya's biggest conversation.
Asante.
Thank you.
Thank you for joining us. I see AJS has a uniform.
No, actually, it's an organic, intruistic linkage. Okay.
This is just because of being together.
No, because AJS is organic.
Things just happen.
It's just-
Things just happen.
Things just happen.
And they're folded.
We wear the same kind of jacket.
You would have added expensive, same color of expensive jacket.
Expensive jacket.
Gotcha.
It's not just any jacket, but style. The designer matters.
Thank you.
Karibuni sana Jackson. We'll be talking about AJS, and you'll tell us the progress so far of the rollout of AJS, how it works, and the thinking behind it. But first, here, this proverb from Ivory Coast.
Yes, our proverbs for the whole of this week have been from the country of Côte d'Ivoire. The weekend's tomorrow. But today's proverb, simple, straightforward. 4 words. Mutual gifts cement friendships.
Mutual gifts cement friendships.
See, when people talk of gifts, one imagines the thought goes to something physical. It need not be. No. A gift doesn't have to be physical. It doesn't have to be tangible.
Doesn't have to be material.
No, it doesn't have to be material at all for it to be a gift.
And you know that idea of gift is so powerful because then it tells us that life is not always about transactions. That sometimes I give because giving in itself gives me an inner reward, inner warmth, inner satisfaction, and it doesn't depend on what you give me back.
What it does, though, it sets in motion that very principle of giving. So it may not necessarily come back to you, but it will be passed along to someone else. Yes.
These days in marriage, under our law, if you give a gift in contemplation of marriage, and then the other person breaches the code, our law now allows you to recover
Your gift.
That proverb did not anticipate.
A return
Should the relationship break,
Yes, then you return
your gift.
The mutuality is more evident.
Nataka gari yangu. But then you see, my friend, you're talking about principles. Since I'm going to make a meal out of this one here, okay? Those who study accounts tell us that after a certain period of time, in their books, the value of a commodity, say something like a vehicle, okay, reduces over time because of usage. So if I'm to go in by the example you give, and your gift is, let's take a vehicle, for example, and a four-wheeled vehicle, not a two-wheeled vehicle, okay, and one which is propelled by an engine, not by your own energy.
Not a cow.
And it's not a
An actual
bicycle.
vehicle.
Yes, exactly. So if the relationship then breaks over a period of time, could you not have utilized the value of that particular vehicle over time so that there is really nothing to return?
You apply depreciation and amortization.
Yes, exactly.
My goodness. Okay.
So, Basi.
See, the Lord decided to quantify relationship. So,
Put it in the books.
yes, exactly.
Depreciation and amortization. Deduct.
Yes.
Value gone. Okay. Daktari, you're the vice chair of, first of all, it's National Steering Committee on Implementation of AJS Policy. Do you have a short
It's a
term for it?
mouthful, I know.
Yes, we have a shorter form of it, NASI AJS.
So when you're going for a meeting, you say, I have the Nasi AJS meeting
We're
today.
meeting for Nasi AJS.
Or just AJS.
Oh,
That's
voila.
It's become so ubiquitous that wherever you mention it, everyone will
Everybody knows what
understand
you're
what you're
talking
talking
about.
about. That's what we intend to achieve.
And the reason why the name is long is because it's the precursor to that committee was a task force which designed a policy. And so the current formation, and myself and Mr. Kimoli were privileged to serve in the task force as well. Our work now is to animate, to build a constituency bigger than ourselves, to be able to propel the AJS initiatives forward. So remember, we are not introducing AJS, we are not sort of the masters of AJS, we're just coordinating it and steering it, its spread to be in tandem with the constitutional values, principles, and indeed idea of justice in the Constitution.
So exactly what do you do? What's the function of the steering committee?
So in the last, we have a 5-year mandate. We are now in our second year, and our work is very easy, layered into 3. The first thing we are doing is to spread the news. So we are broadcasting, and we thank you very much for allowing us to broadcast also using your channel. We broadcast what the policy is talking about. We create awareness. Our awareness program only takes a whole day. We do trainings. And then finally, and most important, we are now working with the various communities at their own levels to model the best mechanisms for ensuring that the AJS mechanisms work in tandem with the Constitution and with other actors. And in doing that, we have encountered 3 types of AJS typologies. The first one is autonomous, where people in their own motion have developed over time a framework, a system of receiving and responding to grievances. The second one is where third parties, which can be state, like the chiefs, constitutional commissions, work with these autonomous entities to be able to advance access to justice. And the last one is what we call AJS court annex. This is where courts of law, and this is quite common in places like northern Kenya. We've seen this work very well in Isiolo. We also saw it work actually in central Kenya, in Nyeri, and in Kajiado, where the courts work with a collective of AJS mechanisms, and these mechanisms refer cases to them, and they also refer cases to AJS mechanisms. But one important clarification that we've seen in the work so far is that when you talk about AJS, you are not just talking about customary law as the anthropological language category, like Luo, Kamba, Luya. No. That is one. It's part of AJS, but it's also the everyday idea of justice, of people organize themselves in various groupings. For example, people in the market. They have, if you go to Kongowea in Mombasa, they have a system of receiving and processing grievance without going to court. And that is AJS. Borders in many places are fairly organized. If you see Matatu Circles, they have bylaws that also help them to develop normative framework that they use to discuss and dispense of disputes.
Even the girls in Nakuru.
Also the girls in Nakuru, we call them the smart ladies. Who
The who in Nakuru?
We
The
know a
smart
lot
ladies.
about them. Yeah.
The girls in Nakuru.
The smart ladies. We call them the smart ladies. We do not want to besmirch somebody's trade.
You've lost me completely.
I am
Me too.
floating on a cloud. I have no idea.
Who in Nakuru?
What is this?
Maurice.
The smart ladies. Please explain who the smart ladies are
You see,
in
he's
Nakuru.
kicked the can down the road, hasn't he?
Properly.
Okay,
Hot
all right.
potato.
Throws it back. Yeah.
Yeah, they you know, they've come together. They appreciate the smart ladies. You know what I mean?
No, I don't.
Oh, children are at home. You know that. It's yeah.
So the
children are at
night
home. The smart
nurses.
ladies.
The night nurses.
What? Yes, the night nurses.
City, what are they called?
They're called sex workers.
Okay.
Oh.
Yes.
Oh.
Okay.
Okay.
Yes, they're so organized that
So
they
in
have a
Nakuru,
system.
they have an association.
They have a system of resolving disputes, and that's what Daktari is talking about. It's about custom. You also have, you know,
Various groupings, people
precisely.
coming together and deciding how they resolve their own issues, but to a certain extent. And you're saying that sometimes an issue may be brought to that grouping. They feel that this is too weighty, it needs to go to the formal court system,
Yes.
and they refer to courts.
Yes.
Or the courts may look at an issue and they decide, we know you people have an organization. Can you maybe go and take this matter there?
Absolutely.
Thresholds for each?
And Kimoli, being a practicing lawyer, perhaps would be the best to take us to this discussion of what criteria that does the court use in deciding what do you accept, what do you allow you to deal with, Brother Kimoli?
First of all, what we realized and what we are telling everyone to accept is that justice is not a preserve of our courts, and that the courts do not render superior justice. Because if you see justice today, you recognize justice, whether you are a lawyer or not. And if you see injustice, you recognize injustice. And a lot of us get justice outside the courts. You know, you have a dispute with someone, it never gets to court, but you go to a forum where, and by the time you leave that forum, you have a sense that you have been vindicated in your grievance. Now, that is what justice is. And all of us will remember that before Mzungu brought the formal courts, we even used to have African courts.
Yep.
Yeah.
And the judiciary, actually, there's a time the judiciary was peopled by lay people, you know, people who are not trained in law. We used to call them lay magistrates. And until very recently, actually, even when I was in college, district magistrate 3 were lay. They were not trained.
Yeah.
By the way, even the provincial administrative system,
Yes.
people who are at the level of, say, the DC, they were magistrates. They were actually the chief magistrates. It is them who dispensed law at that particular level.
Exactly.
Please continue.
So now, with that realization, the Constitution, Article 159, then tasked the courts to recognize that justice can be delivered otherwise than through the formal court system. And Dr. will tell you, and the Chief Justice has been saying many times, that studies that have been done indicate that, close to 80% of the disputes are resolved outside mainstream court system. And if all the disputes were to come to court, then the courts would have no capacity to resolve.
To deal with them.
We already have a challenge dealing with the less than 20% of the disputes that go to court. So that realization now moves the courts to begin a process of mainstreaming those other modes of dispute resolution. Not formal so much, when you talk about arbitration, arbitration is so formal that there is a very small difference between arbitration and the formal court system. And arbitration will still end up in court. So the Constitution, Kenyans realize that our autonomy as a people requires that we discover that we can do this for ourselves. And we've been doing it. Even as we sit here today, Eric, there are people seated under a tree. There are people seated with their pastor. There are people seated with their chief. There is a probation officer somewhere resolving a dispute. There's an OCS who has, people have come to him and he says, do I have to take this to court? Can you go and talk, or can we sit here and resolve it? So the courts have realized that we have to find a way of mainstreaming this. And that's why Dr. is saying that now we are training people and popularizing the aspect of the courts working with the systems as they exist. And what we do in AJS is to be very careful not to introduce something completely new. Because what we did is we went out and sought to discover what modes of dispute resolution exist, so that if you find it and it's working, and if it's not broken, don't fix it. So we tried as much as possible. We even avoided developing a code. Perhaps it will come later, a code of law, statutory, saying 1, 2, 3.
Yeah.
Because it is very difficult when you look at the different nuances of alternative justice systems. It's very difficult to develop one code that can then address all those nuances. So we steered clear for now and decided to recognize what exists. And so what we are saying is that when parties come to court and the court discovers that there is a mode through which that dispute can be resolved, it may not exist in the way you know it. Like we're talking about the smart ladies. You see, you may look down upon an association like, an estate association. They tell you, look, they come to you and they tell you, oh, look, we have our way of resolving these matters. Could you allow us to go to our estate association to try and resolve
And
this
sort
matter
this out,
that involves, dumping of garbage. The court may decide to continue with that matter, or the court may decide to recognize that this dispute should go. Or they may come to court and say, we had a problem of garbage disposal.
Yeah.
And this is a member of our estate association.
Yeah.
We've been talking to him. We have a code that requires, and we sat down and we decided, because you are the one who dumped garbage here, you need to take it away. And the court can decide to listen to that decision, or the court can say, we want to hear this case afresh. But these people have a code. They say, if you dump garbage here or on the driveway,
You collect it and
You-
pay
you
a
collect
fine
it.
of 200 bob.
and we sat down, we decided it is you who dumped garbage here, and you need to collect it and you pay the fine of 200 bob. So if they come with that determination, we are telling the court, now this, accept and appreciate that this is a dispute that has already, as long as the person participated willingly,
Yeah.
as long as the law was followed and justice and human rights were followed. So the courts have a multiplicity of ways of recognizing that alternative justice exists. Yes,
No, sorry, please go ahead and
when they come before you, you look at the dispute, you can ask as a court, and courts are doing this every other day, including yesterday when I was in court. The courts are asking, is this the kind of a dispute you can resolve, elsewhere? People are fighting
Can
in
you sort
marriage.
this out locally?
Precisely. People have
Mnaweza sort hii mambo
Right.
kinyumbani.
Mnaweza maliza.
So with that recognition then is my question. So then does it then come into kind of like a referral system? Because if we're saying that the recognition by the judicial system of this alternative justice, resolution, or rather a justice system, what we're saying is that with the recognition then comes a referral that is accepted by the courts across board, so that they don't even have to come to court and say, here's this issue, and then the court will say, now go back. But that if it becomes recognized by courts, then people who have already an established system of resolving issues already know that this has been recognized, it's been established, it's been recognized by the court, so we can just go ahead. Or are we saying that they still have to come to court? Then the court will say, okay, we see that you guys have a system, then go back.
Now, that's a very important question. Now, you have to read Article 159 of the Constitution. What does it say? Judicial authority is derived from the people. So there need not be a referral mechanism. Judicial authority comes from the people donate it
To the institution of the judiciary.
That means we should have a situation where if I want, I can go to court. If I want to exercise my own residual judicial authority, I can exercise it.
And we are doing that a lot.
Okay? But if need be, that after we have exercised it, we want it to be given force of law, then we can take it to court, and the mediation rules have allowed a mechanism where when you have private settlement, you can take it to court.
But surely,
and get
Dr.
sanction
Akot,
of
there
law.
must be a threshold. There are some cases that cannot be handled.
Exactly. But before I go there, I really would like us to get this logic clearly, that the purpose of the Constitution is that the people are the principals in this country. They donate authority to the executive, to the judiciary, to the legislature. So therefore, the operation of AJS does not necessarily require that there must exist a referral mechanism. That advantage exists. But so the first thing is that they have the power to exercise, but then they can also do referral.
Donate it.
And you're right. Then because of the structure of Article 159 2C, the courts cannot say, hii hatujui, hii ni
Hii ni yenu.
Kangaroo court, ni yenyu. Hapana. The court is duty bound, as Mr. Kimulia said, to listen. Then to the second question, is it all that matters? Again, this is very important. For many years, people are largely saying that, look, the only criteria of deciding that which can be handled in AJS and that which cannot is the categories civil and criminal. We are saying, no, that's not necessarily the single most important test. We have seen that there are elements in what you call criminal matters which can be handled in AJS. And of course, there are elements in civil matters which require the intervention of the courts. So the test that we are suggesting is based again on this notion of freedom, which Mr. Kibuli is saying, first of all, have the people chosen by themselves that we want to do this? Yes. Then we go to the second test. Is there a law which says that this kind of a matter cannot be dealt with in this forum? For example, if you come to matters of defilement, both Sexual Offences Act and the Children's Act are very explicit that because a child first cannot consent, so you can't deal with that in AJS.
Now, legal scholars.
Yes.
And those two pieces of legislation unconstitutional then?
Which ones?
Those two.
Why?
Because they're restricting. If, like you said,
Yes.
the judicial authority is vested in the people,
Yes.
the sovereign,
Yes.
okay, and they can decide. If a community decides to come up with a way in which it addresses issues of defilement,
serial defiler,
FGM, sexual offences, and all, if a community comes and says it universally kubalis that this is how we shall be dealing with those issues, that act then is
Now, you know the
unconstitutional.
Constitution. The Constitution has two meanings. When you hear the word Constitution, the first meaning is constitute. With the people, we come together.
Yes.
Then what do we do once we come together? Then we agree that this is our grand norm, the Constitution, and this is going to guide us. Now, the same Constitution that guides us basically offers parameters of how to ensure that access to justice is availed to everybody, irrespective of their class, irrespective of their power differential in society. And part of that safeguard is to make sure that the vulnerable amongst us are protected, and that those who are not in a position to be able to competitively access their rights, for example, women in difficult situations, the minorities, of course the children, and so on. There's a particular safeguard that the Constitution offers them.
Okay.
So the laws that offer those safeguards cannot be unconstitutional.
What about something like mob justice? And I don't want mob justice. If you look at it, there is a gang of thieves that has been terrorizing a community for some time. The community elders are well aware of who these individuals are. They've spoken. I know your son is one of them. I know your daughter is one of them. Everybody in the community knows this is the gang of people who does this. They've been terrorizing the it happens all the time. People are aware of who these individuals are. Mob justice is called mob justice for a particular reason. They decide to do this because they've decided, look here, you're terrorizing the people. They exercise their constitutional right as a community of people who have seen that their lives and their property is endangered. And so they take...
In exercise of their judicial sovereignty.
No. So let's talk about
that is the reason why it's called mob justice.
Before Kimuni talks about
so where does this play here?
Can we talk about Article 50? Let's talk about the name.
Yeah.
Should it be called mob justice or mob violence?
Alternative justice.
No.
It should be called that.
Mob means a group of
mob. But what they're doing is it? No. I think first the naming. We should want to agree. The naming is more mob violence than mob justice, because what if justice retains its authentic name, which also means transactions and processes that affirm dignity, that preserve dignity, then actions that are an affront on dignity, it will be difficult to call them
dignity
justice.
Of what?
But let's come back to the thing. Kimuli, Article 50 of the Constitution.
Kimuli, as you come in,
question.
let me just add. So this is a community in an estate, in a neighborhood, all right? There have been people who've been terrorizing them, right? Coming in and stealing and maybe even, molesting people as they enter the estate and all. And the community recognizes
over time,
so and so, so and so. They go and flush them out of their houses. And they sit them down here.
In the middle of everything.
And they read them the charge. That is reading the charge.
Yes.
All right?
Yes.
Utajitetea. Mimi ni wewe, so and so, a witness says, ni wewe, ulikuwa. This is a whole process that's happening. Okay? And for that reason, ngoja tukuonyeshe. They pick a stick. Yeah, they serve justice. Or they continue and they take a rock and they drop it on the guy.
And one thing leads to another.
One thing leads to another.
In the process, you die.
Okay.
And people were administering justice.
Yes.
In the best way they know. I think
for a capital offense.
The danger the danger, we used to even have corporal punishment. You know, corporal punishment is very effective. A lot of these people who steal our resources, by the way, these politicians who are thieves, corporal punishment would work so well. You just get this person, you don't even have to go through a trial. You just get this person, you get muscle men, people who are well fed. You give them some 6 strokes. Let me tell you, corporal punishment is effective. It was effective when we were in school. You would fear doing small misdemeanors because of corporal punishment.
I'm trying to imagine a PS.
Our parents, that PS, you know, get him, tell him, oh, look, now, you see, like here you have an open door policy. Here, I mean, you know, when you're doing the program and people are looking at you, it feels like bathing in the open because people can see you. You know, take them in the open. Give them 6 strokes. Don't even take them through a trial, let me tell you. Next time office. You decide to steal, you will be afraid. But do you know what we did? We did away with corporal punishment because it is considered inhumane. Even in court these days, you know, you used to be sentenced to, you know, 6 years with
3 strokes of the cane.
Hard labor.
And 3 strokes of the cane.
3 strokes of the cane, you know. And in those days, you know, you would be sentenced to death, and the judge, you know, ceremoniously would break the pen so that it doesn't sentence someone else because it has done the heaviest duty in delivery of justice. But we've come so far that we have aligned because we don't exist in isolation. We've done away with a lot of those things. In Africa, it is so effective that if you insult your mother among the Kamba, they would grab you, apply siso, you know, that juice on you, and put you in a sack, the one that has holes, so that you don't die out of suffocation. And then they will place you under the sun. My friend, there will be elders asking you simple questions. Mwana Kimuli, do you think your mother is your mother? And you'll be saying, oh, yes, my mother is my mother. Do you think you will insult your mother again? No, you never hear me again. That used to work. But in justice, it is not a question of the end justifies the means. We take the high road in justice. That is why we have said some of the things that may look like they are effective may actually amount to torture. And you know, you can be tortured to make work easy for the police. And apart from mob justice, mob justice is what you figure out when people descend upon you with kicks and blows and do away with the bad guy. But you know, you can also be lynched. You know, now in social media, you can actually be lynched. And no one is then supposed to ratify, you know, that sense of mob justice where they rise up against you without affording you an opportunity to be heard, or you say things under duress. Our constitution is against that. And whether it is being done by the courts, by the police, or by the people out there, it remains unlawful. And Article 159 says you should never do that. And so we are asking people, even when you resolve disputes out there, walk the straight and the narrow. That's the road that goes to heaven.
City, you had a question.
I did. You see, what I like about our learned friends and the understanding of the law, they give us this delightful hope that we are the sovereign. The guest before you kept telling us we are the sovereign. The power belongs to us, but then we've delegated it. Now, my question is there a point when we can take back our power? We're tired of delegating it.
Of course.
Precisely. Now, this mob justice that you're speaking of,
no, the way you take over, you take back your power. You don't take it to destroy yourself. You can only take it to advance yourself.
There's always that rider.
No.
You can take back your power, but...
Yes.
So do we really have this power?
We do. Look, how many people take their disputes to court compared to those who have grievances? You already had statistics.
80%,
Only
20%.
Only 20% too.
Yeah.
That is taking back your power because
And
you can
look at
decide.
how much money we are paying to our judicial officers to handle that less than 20%, and they can't manage it. We have 20,000 lawyers all battling to handle these disputes. We can't manage it. What if the other 80% came?
You've been capable.
And by the way, if you kill somebody during a mob justice encounter, the law only requires you to identify one person, or to capture one person. You know, there is what is called citizen arrest. People don't know that under the law, members of the public have power to arrest. You arrest, but when you arrest, you take to the police or to court. But if you are identified when people are killing someone, they will take you to court and you'll be charged together with others, not before the court. And you will bear the burden. You may not have been the one who killed, actually. The person who killed may be out there. And therefore, it's very critical that people walk away. When you see people bludgeoning somebody to death, run. Because if they catch you,
If you are the one who's arrested,
you will be charged alone.
just as an observer,
And you'll be saying, oh, I was not alone. Here we say you don't defend yourself by saying, Kimuli is also a thief and he has not been arrested. You defend yourself. You free yourself.
You know the reason why I asked this question? When we talk about the sovereignty and we talk about all the powers that we have which we've delegated, and I look at the poverty levels of this country and the ever rising, and I look at sovereigns in entities that we refer to as kingdoms, those people don't suffer the way like we sovereigns do. Not quite. So, for us to actually internalize this particular idea and to live it, for it to be a lived reality, then other things have to actually work for us to understand that indeed this sovereignty, because what you're referring to as violence is indeed violence, but it is in response to a greater violence that is committed, because it's a state of mind. When you're deprived of basics, that's violence. When you're deprived of rights, that's violence. When you can't access healthcare, it's violence because it abrogates the very, very constitution you speak of and the fundamental rights that we, the sovereign, have within our constitution.
City, you are completely right. I agree with you. In fact, AJS, for it to be sustainable and to move ahead, it must also have what we call a transformational capacity.
Yes.
And this transformational capacity is about dealing with the larger gamut of rights questions, which include social economic rights, which includes relationship between the governed and the governors, which includes relationship between the people and the state. So and that's one of the things we've done, is to really use AJS as a platform for opening up conversations on restructuring our society, conversations on restructuring our relationships. And let me give you an example. If you go to low-income area like Kibra, where everyone is a squatter, if one squatter has a claim against the other one, the court may not be able to process that because both of you are living an illegality. For example, let's say one has sewerage seepaging into the other one's,
dwelling
plot. According to the court, none of you have right to property, and so we can't help you. But AJS helps to appreciate that. Look, you may not have a title. You may be called a squatter because you are an occupier of public land. However, you have certain proprietorship rights, may not be the legal proprietorship rights, but you have certain rights in living here, for which then you must get justice. Now, allowing that starts helping us to think about justice not just for the powerful, justice not just for the property, but justice also for the propertyless. But so advancing this transformational capacity of AJS, as you rightly put it, is very important. That's why, for example, we think AJS can work with smart ladies. Yes, the practice may be explicitly illegal, but it's a social function that occurs under violation.
I've wondered actually, why is it actually illegal? What is it about that particular practice that makes it illegal?
Well, that's a philosophical question. If you ask me, my own standpoint could be different. But I think the idea that you cannot sell body...
What you cannot commoditize.
Yes, what you can't commoditize, and the fact that dignity is something that we cannot negate, makes it problematic to have a commercial venture that sells passion.
That's a legal perspective, isn't it?
Oh, wow.
Yeah. Is this a legal perspective?
In some jurisdictions,
yes.
In some jurisdictions, it's actually perfectly lawful.
Yes.
For you to earn.
Yes.
Some jurisdictions, they regulate, they take you to a hospital, they check whether you're okay, so that they regulate the
hours you work.
And very few people have not bought. Let me tell you, the legal side says that don't buy. But if you are to line up men and ask who has not paid for this commodity,
You will find very few.
oh, few. I mean, few is an overstatement. Few is an overstatement. Wallace Soyinka in Kongi's Harvest says the crown is a burden when the king visits his wife's private quarters. People will call you sir, afande. But when you go to your wife, you look at her, and then she tells you, you touch, and she tells you, wewe, kuna kitu tulikuwa tunaongelelea. Unamuuliza, what was that? I mean, people know you as the commander-in-chief of the Kenya Defense Forces. But there is a point you reach as a man where now you go down on one knee and you say, can we talk?
Who's the real sovereign here?
Precisely. So you see, if at the legal point, you can have these epithets, but when the rubber meets the road, all of us are equal before women. All of us are equal before women. You'll be asked questions. You'll be told no. And there's nothing you can do. You can't bring a battalion. Yeah.
You know the reason why? By the way, you have preempted what I was getting to. You have a law, and the practice of that law is in complete abrogation of the law. You're saying it is illegal, but that's you saying. Everything else points to the fact that that law is yours. Whoever created it, it is you who should abide by it. Everybody else is abiding by the complete opposite of what that law dictates.
Could I retrieve something and deal with it?
Yes.
There are two other observations we've made, and that's important to clarify. One, why do we call this multi-door? What does multi-door mean? This notion of multi-door means, and that's really close to what CT is saying, it means the plurality of avenues.
Options.
That you have a choice to go to court, you have a choice to go to a mediator, you have a choice to go to an agency mechanism, to an arbitrator, and so on. And that's a very generous offer that we have in our constitution, and is part of what we call the indicators of this sovereignty. Choice. Choice is even in a democracy, having choices is a major indication of that. Secondly, is we've seen largely there are some communities and some actors who think that AJS is about queuing towards becoming like the court, and you're telling them no. AJS is not an element in evolution. We are not situating ourselves in a teleological route that all we are doing is one day we want to be like the Supreme Court. So we may be working like, the Luya Council of Elders, but ultimate things be like the court. No. The Constitution says, we like you the way you are. Do what you've been doing, so long as.
Okay.
So long as.
So
It's
is
within
there
these
a
boundaries.
general acceptance of
Yes.
AGS because the burden on the court system is already so heavy, or is it accepted because there is a recognition that other processes could best handle a situation rather than coming into the courts?
Thank you. So there are many people accept AJS for different reasons. But I like the two categories you've given. The major idea that allows AJS is the second one. That, like Kimuli said, even before the courts, we were doing it. And with the arrival of the courts, we are still doing it in our forums. So the court says, yeah, we've seen that judicial authority is derived from you, and we've seen that you have other practices which you like. And the court is told, promote them, don't kill them. And not to promote is not to control, to promote is not to regulate, let them be. However, because we have allowed the court to be the central dispenser of justice, and we call this orbit theory, which is different from what we had in the colonial time. And City, this is important for you. In the colonial time, the African court was seen to be number 4. And the European court was number 1. Now, AJS is not number 4, and that the formal court is number 1. But what you have is like a circular form, shifting away from the Ngazi form to a circular form, where the formal court, the state-based court, is at the center, and all the others circulate around, it's like the orbit, circulate around the
sun.
So the sun has the obligation to release the rays What are the rays? This rays is adherence to human rights, rule of law, promotion of dignity, and so on. And philosophically, it's very important because it's about really affirming this sovereignty, which we are contesting, to what extent does it exist, what extent that it does not exist. But also saying we have agreed how to live as a people. That's why we have a constitution. We have agreed how to live as a people, and that part of that agreement is no discrimination, no violating Bill of Rights, no, negating human dignity, and so on.
Dr. This statistics of 80-20. So we say that 20% of people who are seeking justice will go to the formal system, and 80% will go for alternative justice system. I have a feeling it's erroneous.
How?
Because it's presupposing that everybody who seeks justice ends up somewhere. Are there people who would want justice who actually do not end up in any
Yes, it's true.
of the systems?
It's true.
They don't go into the alternative justice system for one reason or the other. They feel discriminated. They feel they don't have confidence in any system, or they are restricted by one thing or the other.
Yeah, there is this Swahili word, kubali aishe. There are people who fatalistically say, well, it's happened. So this actually, maybe we didn't give the right rider, but the statistics are about those who choose to seek redress. It's 80% of them who use AJS and 20% go to courts. But there are many people, unfortunately,
Who turn the other shot?
who turn the other shoulder.
The other
The other cheek.
Turn the other cheek.
No, but there also may be people who may want to seek redress, but they feel locked out for one reason or another.
Yes.
Because maybe of their status, their social status, their physical status, they're living with disability, and so they don't have access to their community has already ostracized them. So this community, the alternative justice system, will not accept them because it doesn't regard them as human enough to come there. Are there such?
That's very true. Before I give it to Kimuli, it's important for us to recognize, and you're right, AJS is not this perfect system. In fact, it's a system that is in itself in a lot of internal conversation. So, for example, what do you do when you have mixed culture? For example, you're a border person in a community of mkokoteni riders. Will you use mkokoteni normative system or border, or you are a courier among the Luo, then you are forced to use. So there's that problem. We still have problems of gender. We have so-called elders who insist that women can't sit in those spaces. And who is an elder? In our idea, an elder is not just somebody with multiple white hair like one of us, but an elder is a category of honor. This is very important. And that means a youth
Can be an
in the
elder.
age's logic can be an elder. It's a category of honor. What is honor? Look at Article 10. This dignity, these issues of accepting non-discrimination, sharing of power, and other values that exist in our other cultural societies. The idea of honor. So it is true that, yes, there are certain circumstances, many circumstances. In fact, my own finding and our committee is that many so-called, I use the word so-called, justice mechanisms that exist in our communities lack in their idea of centering the victim. So you have justice system which operate not in a manner that sees the victim as a target. Take, for example, among the Agikoyo, there is this custom that if you break a girl's leg by
Getting her pregnant
outside the marriage institution of marriage, then what you need to do is to pay a goat. And after you pay a goat, you are set free. But what happens to the right of the child? What about parental responsibility? It all falls. And that's problematic. So part of what we're doing, and that's why we're really intensifying the awareness, is to make sure that AJS is not a space for giving poor justice, for giving weaker justice, for giving lower justice. The threshold of justice, as we are invited by Article 48 of the Constitution, remains the same, whether through AJS or through the courts.
And all of them remain accessible to all.
And all of them
Let
ought
me
to be
add
accessible.
something, Eric, so that I can...
in 30 seconds to conclude.
Yes. When you say that you can avoid resolution of disputes one way or another, it depends on a lot of things. Number one, if you children are playing and something happens, you may not want to go and report to your mother, but somebody will report you. Now, you may not want to go to a formal justice system, but if you get into trouble with anyone or somebody feels that you have trespassed into their space, they will take you to court. The court will summon you. If you don't appear in court, judgment will be rendered against you. You can be taken to the elders will summon you. So you may not want to be the one to take the step, but the system is structured in such a way that even when you want to remain aloof, tomorrow somebody may
You can have an advocate.
Yes, somebody may drag you into the system. And that is why we're saying it's very difficult not to have someone. The only thing you can't do under Article 44 is to force someone to accept your culture or to drag them into a system of dispute resolution they don't believe in. The only central dispute resolution system that has command power is the court.
Courts. Gentlemen, thank you very much for joining us. Asanteni sana. We've learnt a lot this morning on AJS and how far AJS has gone. Dr. Steve Ouma Koth, Vice Chairman of the National Steering Committee on the Implementation of AJS Policy, and Committee Member Maurice Kimoli.